Okay. Good evening, everyone. It's my pleasure to welcome you all to today's webinar on personal insolvency, which is regarding the legal framework and practical issues. So we are fortunate to have with us IP and advocate Devrat Rana. So as our esteemed speaker on today's topic. So as you know, today's topic is very much relevant as personal insolvency resolution and bankruptcy is gaining wide acceptance among the stakeholders day by day. And everyone is well aware that personal bankruptcy is enacted in Part 3 of IBC and comes into existence after failure of the repayment plan or other relevant provisions are applicable. So I want to extend my heartfelt thanks to Shri Ashish Makija, President of IPNet, whose leadership and vision continue to propel this platform forward. IPNet has quickly evolved into a cornerstone for insolvency professionals across India. It has become much more than a network. It's a vibrant community where professionals come together to exchange knowledge, tackle challenges, and grow in their careers. So here at IPNet, we are committed to meeting the critical needs of IPs, including continuous learning, timely, reliable advice on the matters related to IBC. It is a powerful forum to voice concerns and find practical, actionable solutions. So in response to these needs, IPNet offers several standout features. Specialized study groups that engage in ongoing knowledge sharing, webinars and discussions on the latest industry developments, a dedicated member portal providing easy access to resources that address all your professional needs in one place. So I welcome all once again, and now I invite IP Parag Singhal ji to play a short video showcasing IPNet's purposes, initiatives and contributions. He will also be playing a short video on IPNet website to show its features and benefits. Over to Mr. Parag.
Thank you, Sandeep ji.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Okay. So now I would request Mr. Parag Singhal to introduce our speaker, Mr. Devrat Rana.
Thank you, Sandeep ji. Am I audible, sir?
Yes, very much audible.
Friends, we have among us one of the prominent speakers on this particular topic, Mr. Devrat Rana, who has over 25 years of experience in real estate, hospitality, and infrastructure sector across geographies with firms like DLF Limited, ETA Star Dubai, APECO Infra, Airport Infra, etc. Devrat is active in the insolvency and bankruptcy field since August 2017 and has successfully handled multiple assignments under IBC code. Currently, he is a partner at RRR Insolvency Experts LLP. In the past, he acted as director at Whitworth Insolvency Professionals Private Limited between 2018-2021. As an insolvency professional practitioner, he has been acting as interim resolution professional, RP, liquidator, RP for personal guarantors, and bankruptcy trustee. He has represented resolution applicants in different COCs under CIRP and have prepared resolution plans for successful RAs. He also advises and acts as advocate at different NCLTs and NCLAT. He is empaneled with different bank for insolvency professional services. Friends, please join me in welcoming Mr. Devrat Rana. Mr. Rana, over to you.
Thank you, sir. Thank you. Am I also audible?
Yeah, sure.
Okay, perfect. So we have approximately 59. Okay, so 59 people here. Good. Thank you, people, for inviting me here. And though bankruptcy, we are in the 8th or 9th year, but bankruptcy is still new to us. I'll tell you why I'm saying so. I'll start with a small data points to confirm what I'm saying right now. We'll go through the session. Though, I mean, most of us have been uh, insolvency professional in personal cases, but bankruptcy trustee, not many should be here. But I think that time has come now where, we will transition into a bankruptcy trustee. I'll try to take you through all the sections starting from 121 onwards. Uh, we'll keep it interactive. Any question you have here, please feel free to stop me. I don't get disturbed by, the flow doesn't break or no such thing. Please feel free whenever you want to stop me because I guess here we are, equals teaching equals. So there is nobody that I know more or somebody know more. We are all learning because if we are all not learning, then Anil Sayal would not have happened that 3 months back, one NCLT saying don't discharge him, and after 3 months, NCLAT says no, you should discharge him. So obviously, it's a matter of opinion. Uh, my opinion, I will share, and as an RP, as IPs, your opinion, please enlighten me also and everybody else. So to start with the data point, let me start my presentation. Uh, somebody has to allow me that. Uh, sharing. Okay. Now I think I can share. My screen should be visible, right?
Yes, sir.
Yes, it is visible.
Okay. So let me make it little bigger. So today, I mean, Parag ji had introduced enough about me. I am active in this field from last 7 years, and luckily I have been part of. So I'm a bankruptcy trustee also in one of the matter. So, so far, as per the data shows, I'll show you how many number of cases are there. So, before we start, may I know anyone here who is acting as BT? If anyone here already acting as a bankruptcy trustee,
Sign.
Mr.
I
Shivaram?
I am also acting as the bankruptcy trustee.
Okay, Sapanji is
I'm also
our
acting as a bankruptcy
ex-partner.
That is why
Sorry,
I'm in
who's
this
that?
seminar. I'm interested to understand
This
this.
is Mrityunjay Singh.
Mrityunjay Singh ji is there, Sapan Mohan ji is there. Okay. So I guess they will be my co-presenter in this case because we are still learning. I'm admitting on day one that we are still learning. We will take you through what is going to happen, how we take it up. 1 hour or so. Then we'll take questions in between. But as far as I'm concerned, please feel free to disturb me. Okay, no problem. So this is first slide only. Okay. Some data points I would like to share with you, before we start. And this is as per the IBPI's letter, last quarter, ending on 31st March 2021. Total number of personal insolvencies which have been filed at DRTs and NCLTs, 4203. And out of which 613 have been filed by the debtors themselves. Creditors have filed, how much? 90%. Whereas as IP, we all keep hearing that, bankers, they say that 94 is used to put a stop on SARFAESI action and this and that or getting misused. But the data shows otherwise. Data is pretty clear. It says only 10% are filed under 94. Rest are 95 applications. Out of 4,000, only 600 as 94 and 3,590, which is exactly 90% goes to bankers, 94. Now, obviously, this is too much data. We don't need all that, in which year, how many were filed, etc. But I think this is an important data point whenever you're interacting with bankers. I guess keep it in the back of your mind. They keep saying that promoters are, acting funny, taking advantage of Section 96, interim moratorium they utilize. That is one part, but data shows that 90% is filed. Okay. Now, individual insolvency, as we have already learned, out of 664. Let me read this. This is important because normally IPPI says that you should know about it. We will know about it. Of the 4,200 application, 120 were withdrawn. That's all. 135 were withdrawn after appointment, etc., and 664 have been admitted. So not a very big data point as such as compared to CIRP process maybe. But the recovery, it shows that it's bit dismal because it shows at 2.49% of the admitted claim. Only thing we need to remember here is this admitted claim is a lot more than than the recovery we could have expected. See, when it's a personal insolvency, it's not only you may start the personal insolvency of a PG to CD only because there is a guarantee. But the moment it is admitted, then it becomes a process in RAM. Then every office creditor will come into picture, and not only the guarantees. And that is when this number goes, pretty high. Recovery is at times only this much, 2.49%. Now, that is a general case. It's not that there is no recovery. In one of my case, my own case, we have recovered 100% money. Absolutely 100%. In Pioneer Urban case, Central Bank of India, they had a matter. We got full money. Though it was a small matter of around 11 crore something. But still 100% recovery, right? If you talk about percentage, there is a possibility of getting 100% also. Now, coming to the next slide, which might be a bit interesting, is individual bankruptcy process as on date. And this, again, I'm saying it's on, till March, as per the data available with the IBBI. Maybe in 2 months, if 2, 3, 4 more have admitted, might be changed. So 63 applications have been filed till March 2020. And out of 63, 2 were filed by the debtor themselves. We know section 122, 123. Both of them can, everybody has an option. Once the PIRP fails, there is an option. Anybody can go under 122, 123 bankers can go. 2 were filed by the debtors themselves. 61 were filed by the creditors. And 1 application has also been filed at DRT Chennai. Now, I don't know if every one of you are pretty clear on this part or not, that what is our AA, adjudicating authority. Now, even after 8 years, I don't think anybody can, 100% convincingly say that no, it is NCLT. Though now we have developed 4 criteria, that if CD's insolvency is going on, or it has already finished, or it has, or let's say it has touched NCLT in some way, then we go to NCLT, otherwise we go to DRT. Correct? That is our understanding, or any different view anyone has?
And sir, may I ask something?
Yes, please.
So you rightly said that this might also go to a DRT because of the very fact that CIRP is not ongoing, CIRP has not been initiated, or various other things are there. So
Correct.
think it, what is your experience regarding DRT? So what I have heard is that it is pretty slow, and so cases are not admitted. And what is your overall experience about DRT admission and all?
Sir, if you see DRT, there was only one application, right? So nobody has experience, let me tell you that,
Okay. Okay.
right? So DRT regular experience of SURFACE, we all know they give you 4-month date, right? Uh, 3 months, 4 months, come after Diwali, they do like that. So people are same. I don't know whether they are now changed, and they have changed their thought process as per IBC also or not. Because in SURFACE, there is no such timeline. Imagine you getting a 4-month date. What will happen to our process? So, I, sir, personally never filed any DRT PG application also, neither the bankruptcy. But yes, anybody here who has, I mean, all of us are IPs. I'm sure people have experience of going to DRT. DRT, the biggest problem is time delay. That is
Time.
our, we are scared to go to DRT. Because as at NCLT, we believe that 7 days do this, 3 days do this, 4 days do this, 48 hours circulate the minutes, etc. Right? Whereas in DRT, I mean, if we say them that it's urgent, urgent means come after 1 month. So, sir, Sandeep sir, no personal experience of how they are taking it as of now. But just to bring to your notice this one application, the PIRP also was at this bench itself. It was between KEB Hana Bank versus Mr. Rohit Nath. It was in DRT Chennai 2 bench, and I think it's a 2022 matter. Pretty initial stages. In
Okay, so
fact, sir, at that time, it even went to Madras High Court, and the matter which went to Madras High Court, they said, okay, now since CIRP has started regarding that particular company, now this should be transferred to that particular NCLT, which is normally there, right? We do believe that, correct? That if
correct.
that particular start, that it should be transferred to them, right? But Madras High Court Division Bench, 2-judge bench, they said, no, DRT Chennai, you continue, you finish it here and itself.
Okay, so that is strange, sir. As per
We
the
are in a
law,
a
as per the
strange
law,
world,
should be
sir.
transferred.
We are in a strange world, sir. So Madras High Court order dated 33/2023, they confirmed it. Okay, so that is what I'm saying. When you are an IP, RP,
Excuse me, sir.
have good legal team with you. Yes, Mr. Kashi.
Yeah, is there any other case which is, filed in NCLT? Similar type of case? CARP not initiated, PG initiated. In such case only they have approached DRT, na sir?
Correct. In such case only they go
So,
to
where
DRT.
CARP is not initiated and PG is initiated, is it filed with NCLT? Any other case is there?
Sir,
We have, yeah, please.
I think, sir, there's a Calcutta NCLT case where the CIRP was not initiated or pending, and the PIRP was dismissed. It was SBI versus Nikunj Kothra, if I'm not wrong.
Ms. Priyanka ji, by any chance you are RP in that or?
No, I wasn't the RP in that, but I'm
Okay.
aware of this case.
You are aware of it. Okay, so Kashi ji, this is the benefit of having, experienced people with us. I was not
Sir,
aware
I am not having
myself.
even, I'm not even handling even a single.
Sir, even Bombay
Very better.
NCLT, where I was appointed as an RP, they have a matter where the RP has not initiated, but financial creditor has filed
Approached
Section
NCL.
95. Yeah, so that is
And
still not
is it
admitted.
admitted?
Not
Okay, not
yet,
yet.
but yeah, not yet.
Okay. But sir, Kashi ji, again, I have to admit, we are not 100% clear. I don't think anybody 100% is 100% clear. My personal view, go to NCLT, don't go to TRT, file it there. If you are working as an advocate, approaching DRT will only spend a lot of time. Uh, as we were discussing with Chitkara ji, Madras High Court though confirmed, they even allowed 1 lakh rupees to this creditor, which is KEB Hana Bank, that the cost should be paid to them for 1 lakh rupees. Why it has come to this place? So courts can take any view. Now, in my opinion, we'll approach NCLT much better than going to DRT, unless your bank is hell bent on saying that no, stick to letter of the law only. According to me, currently, if the CD has not touched the cornerstone of NCLT ever, neither pending nor removed nor liquidation, nothing, then you go to DRT. Otherwise, please be happy and come to NCLT. That is uh, okay. So why I wanted to bring this point is only 63. So our experience of bankruptcy arena is only 63, and that too we don't know at which stages they are, because there were two rounds of litigation, right? Lalit Kumar Jain and Dilip Jiwarjika. Now every 2 years, a lot of applications gets accumulated and they reach Supreme Court. So first it was Lalit Saab and then another 380 applications through Dilip Jiwarjika. We went there and applications kept pending. Now there doesn't seems to be any hurdle in admitting cases at bankruptcy. Now, in fact, there are cases where NCLAT also has upheld that no repayment plan received, time is over, thank you, go to 115, file your bankruptcy. There is no such thing that he did not. In one of my case, my PG, he just wrote me a mail that I am exploring other options. Just one line. I am exploring other option. That means I am exploring appeal, etc. Right? And obviously there was no plan. I filed the application to NCLT that there is no plan. It may be closed, may be allowed bankruptcy. Their entire challenge till NCLT Chennai, it is still going on. They say that we never said we are not putting repayment plan. We only said we are considering other options. Where did we deny it? And then I'm fighting that what is the meaning of saying we are exploring if it is not denial? And 2 years went into admitting that, believe me. And obviously he was part of that Dilip Jiwarjika batch also, where they appealed and then finally it was admitted. But even one word people are fighting, and as an RP, as BT, you should be very careful when you're answering or putting any even single word. Imagine one line only answer. And it took like 2 years just for this, that where have we denied? Okay, so bankruptcy 63 only. One of I am here and two people, our two of our esteemed August people are here. We will discuss that, sir, at what stage they are. Okay, so before we get into it, there might be some people who are not even till today, they might not have got the case and they are still looking for to become a PG and BT. So I'll go through them very fast. I'll start with more of bankruptcy. But there are, since these slides are there, these are around 50 slides. I'll rush through them pretty fast. If you still feel there is a need to stop me and, talk about it, we can, feel free. Otherwise, we'll straight away go to that section 121. Fine. So individual insolvency bankruptcy, right now only applicable to PG to CD. Partnership firms, etc., is not yet here. Starts at section 78 and goes till 120. 78, 79 is notified. 80 onwards till 93, nothing. 94, yes. PG to CD regulations are there. We all know they all came in December, 1st December 2019. Exactly after 3 years of CIRP and liquidation. So 78 to 120 is our insolvency resolution. If it fails, we go to bankruptcy. And there is no direct way to go to bankruptcy. Correct? Like in voluntary liquidation, we can go right directly, but there is no voluntary bankruptcy. Normally, we try to compare bankruptcy with liquidation, right? So there is no voluntary bankruptcy. You have to go through the insolvency resolution process. Then only can go to bankruptcy. Okay. Guarantor means a person who is a personal guarantor to a corporate debtor and in respect of whom guarantee has been invoked by the creditor and it remains unpaid in full or part. Now, do all of you agree that it's unpaid in full or part makes sense or it's too much? If it's not paid in full, it's fine, but unpaid in part also is a problem, isn't it? In one of the recent case, the CD entered into an OTS. OTS has been accepted. OTS accepted. So CD has no default now. Right?
Right.
So OTS doesn't mean that 100% is paid, right? Let's say 95 is paid. 5% was remaining, isn't it? Now, what happens to the guarantor? Can the bank go if they have already settled through OTS with the CD?
No.
Mrityunjay ji is saying no. Gauri ji is saying no. Anybody else saying no?
Sir, because settlement has been happened for the whole debt. It has not been for the particular borrower. It is for the
Very
debt.
good.
This is my opinion. Might be wrong.
Gauriji, please feel free. Here, you can be wrong as possible. Don't worry. So when we go to COC at that time, don't be wrong. That time, whatever you're saying is the law. Here, you can
Maybe
afford to be wrong. It's okay. Yes, Kashi.
maybe the OTES the bank might have accepted, thinking that they can still proceed against the bank personal guarantor, because personal guarantor is having ability to pay the balance, whatever that was sacrificed to the CD.
So doesn't it depend on the terms of settlement? Maybe it is covered there.
No, so I'm asking who is saying no, they should not, like Gauriji. Who is on the side of Gauri Deshpande?
I'm there. You should not.
Okay,
like, once
Mrityunjay ji is
yeah,
there. Okay.
Yeah, once OTS is done, then it's done.
Yes.
You need to conclude at that point of level, that level only. You can further cannot pursue with the guarantor.
Okay. Unluckily, sir, NCLT does not agree with you. Okay. So they said OTS, what Kashiji was saying, and Namrata ji, obviously, if the terms were so clear, then this question would not have come, isn't it? So, and that is where I insist that you are doing an OTS.
The commercial wisdom
In-
part will
in-
come here. Right?
Sir, not only commercial wisdom, involve a decent lawyer. Spend 5,000-10,000 rupees, make this proper. Now, what has happened? NCLT allowed, they said that since it is not paid in full, and the guarantor, see, the line is here, remains unpaid in full or part. if they had included one liner, Namrata ji, that this will also go away, obviously they had no chance to go back. They went to NCLT, NCLT admitted it. And it was not a very small amount, it was a decent amount. So, I mean, on LinkedIn right now, I think in morning also I commented in one of that. If some of you are linked with me, you can saw that case law. So, bankruptcy, we don't understand. Okay, and I'm not saying it will stick. Huh? I'm still saying, Mrityunjay ji, I might agree with you that at Enclate they may do something,
Correct,
with
sir.
it.
Once the OTS is signed for 100 rupees and the party has paid only 95 rupees, then yes, they can pursue it, got failed.
No, provided
Once
he
OTS has been
guarantor
signed
is
for
also a
100.
party to that. Guarantor is also party of that OTS. Combinedly, they
Yes.
have given the consent that the OTS clears even the guarantor. Then it will be okay. Suppose if they are
Absolutely, sir.
entering OTS only with the guarantor, sorry, corporate debtor, and excluding the PGs, then the COC may be of the view that they can proceed against PG for the rest of the amount.
But in this case, OTS, in the normal law of contract,
Law of contract is.
once the creditor is agreed for lesser amount, the guarantor will also be free, be liable to pay
238 overrides that, sir.
IBC is overriding, but the normal law of contract.
Normal law is okay, fine, yeah.
OTS is approved by the bankers out of the IBC.
Mahendraji, unluckily we are not dealing with normal law. That is a problem.
So, but then the guarantee till it is revoked, it stands. So the guarantor is not discharged by way of OTS. So I think they're justifying it.
Good. So here itself we have half this side and half that side, isn't it?
OTS is approved out of IBC or under IBC.
OTS is OTS, sir. You approve it, however.
It is always approved out of the IBC.
Well,
there is no OTC in IBC.
OTS is
There
not in
is
IBC.
no, there's
OTS
only
in IBC.
90A. There is only 90A in OBC.
RBI scheme, sir. OTS under RBI scheme.
RBI or individual banks schools.
So in that case, the normal law of contract will apply, not IBC will apply.
Sir, then 238.
No, once it has come into the net of IBC, I think no one can escape.
If it's come into IBC, then the OTS is approved, then the proceeding will continue against the guarantor.
Sir, if they would have come under, if they were so good and they were so aware of it, they would have mentioned one line straight away. Obviously, they never imagined this, isn't it? They never imagined that we are doing OTS, but the bank will still go after them, isn't it?
But whether OTS will stand after the settlement is done, the guarantee will stand after the settlement is done.
I think, sir, most of the OTS, no, they are not absolving the personal guarantors from their liability.
Yes.
That's why I think they are going ahead with PGs.
If no proceeding is pending against the guarantor and OTS has already been approved, then proceeding under IBC against guarantor will not go.
No, go or not start?
Not start. Will not be permitted because
no, sir, that is a wrong
the creditor is binding by the OTS amount.
No, wrong understanding, sir.
Sir, as far as I know, all OTS are being approved without absolving PGs from their liability.
Yes.
Intelligently, banks are doing this. And pre-IBC, no bank has gone ahead. Now, since IBC has came, they become intelligent and now they're going against PGs.
Absolutely. Guptaji, that's what I'm telling you. Sir. Now we need to learn. And that is why we are doing this seminar or, whatever we are discussing here. And in the beginning also, I've said, whatever Mahendraji knows, I think Mahendraji knows much more than us. And Guptaji knows much more than Mahendraji. But we are learning here. We are only discussing.
Yes.
Exactly. We can make mistake here. We can talk here. We are equals, right?
Yes.
Maybe age might be 10 years here and there, but end of that we are at the same level.
We are sharing the knowledge.
Absolutely.
We are sharing the knowledge, sir.
We are sharing the knowledge, sir.
Correct. So if you are part of such settlements and you are representing the CD or the PG, ensure that you write it. Because even this kind of thing can happen. That one way you're giving money, but you're not absolving the PG. Whereas if you know in CIRP, lot of places they are now putting in the plan itself that PG will be removed then only. Remember, there are so many SBI cases where in the plan itself they absolve the personal guarantors. Unless you do that, it will not be applicable. So you have to clearly write. When you write clearly in the repayment resolution plan, you might always write that in the OTS also. That was the whole idea behind bringing this to you. Now let's see the sections, how it is spread. IBC part 3, chapter 1, 78, 79, we know is application and definition. Fresh start, not yet there. So 80 to 93, we don't have. Chapter 3, part 3, chapter 3 is very well there. We are all doing it right now. Chapter 4 is our bankruptcy order. Now imagine this 4 and 5 have to be separated. So two chapters, two big chapter. Bankruptcy starts from 121, goes till 178. Anyone knows what is 178?
Concerned is windfall, I mean waterfall.
Waterfall. So exactly similar to 53, which is in our personal, CIRP. Same way we have 178, which we should adhere to, etc., etc. Correct? And then adjudicate the authority. We have already discussed that point number 6. We are still not very sure.
Are you sharing the presentation? It's not visible.
Right, it's visible.
Not visible.
It is visible.
Madam, it is visible. It might be some problem with your system. Please, you can re-log in.
Okay, ma'am, please see once again. So, okay, so we'll continue.
Yeah, sure, sir.
So definitions, I guess we all aware by now. 5/22 means debtor who is a personal guarantor to CD in respect of whom guarantee has been invoked. Also, this invocation, whether this invocation is how to invoke it itself has been subject to thousands of litigations. Whether it was properly invoked, not invoked, whether sending a notice itself means invocation. In NCLAT, recently they have said no, sending a notice is not invocation.
Format is.
The word has to be very clearly said, invocation, unless that it is not there. And it has to be properly served. So recently one of our IP was suspended because that invocation notice he did not check whether it was delivered or not. Only because of that. I mean, that was little harsh on, I believe, on IBBA part. But his 2 months was left in AFA, 70 years of age. So, but it was suspended just because of, I mean, he didn't check whether it was delivered by the speed post department, government department or not. They're saying if you have not even checked that, what have you checked? Now, in your view, our view, or maybe at least my view, how many RPs have rejected Section 99 report? I don't think anybody here would, if any one of you are here, if you can guide us, please. Anyone has rejected saying in 99 that matter should not be admitted if you are appointed?
If
So I
it is
guess
out
no
of
answer,
limitation,
right?
I think it can be rejected.
No, sir. I'm asking experience. Do you have any
Yeah, yeah.
experience of rejecting it?
I recommended for rejection based on limitation, but NCLT did not agree to that. So they admitted it.
Okay, so first person who at least recommended the rejection, right? Otherwise, it's a pretty sad situation. See, 99, if you reject it, if you say reject it, then what will happen? You will
Yeah,
never
of course,
get a case.
I said it that it's a NCLT adjudicating authority's purview to reject it, but my recommendation is to reject it based on time limitation. That was
Parmod,
my
it's always their purview whether they admit or not, right? Our admission rejection is only recommendatory, correct? Not Chandrachud Saab has very clearly said that. You are first person. I'm happy to hear that you have said that it should not be admitted. But otherwise, why will RP say, and I can say this only among IPs, right? I'll not say it at NCLT or IBBI forum. But why will an IP reject an application if, and it's a matter of opinion again, right? If a banker has appointed you and the RP himself is rejecting it, is it even possible? So in my view, 99 is more of a formality than, you know, actual adjudication or proper recommendation. I think 99 is more of a, we are, accumulating everything point wise so that NCLTs can put a tick on it. It's okay. So we'll skip it for the time being. 126 of the Indian Contract Act, important for this. If you can't remember, just remember 126, there is a section that a contract of guarantee is defined there, right? 126, 127 till 129, NCLTs are discussing on this part always, the guarantee part. Section 29 is about debtor judgment. We don't need to worry. Okay. In personal insolvency, there is no such thing called financial credit or the operational credit. Correct? That means debt. Here, there is no distinction. Only distinction is between secured and unsecured. That's all. Otherwise, there is no difference. Corporate guarantor, a company giving that. Finance, I mean, will not spend time here. So these are some of the judgments. Dilip Jiwajika, you are aware. Qualifying debts and excluded debt. Anybody would like me to dwell upon, or I can move on?
Maybe, sir, you can just tell us in brief about this.
Okay, so qualifying debt. See, IBC is for resolving the insolvency related to debt, not fines, crimes, etc. So 138, all those problems are in your life, that will not be absolved. SEBI has put a fine on you, it will not be absolved. Only debt. You want me 100 rupees, you have only 70, let us discuss it. IBC is only for that purpose. So qualifying debt is that,
So,
which can be resolved. Yes.
So, how should you deal with cases of personal nature? Let's say a divorce case is pending, something like that, which is still not material. The judgment has not been passed, but it is still pending. How should you deal with it in the repayment plan?
How can you deal with it?
I mean, should you put a rider saying that subject
You
to
can't.
these debts?
No, you can't. That is a separate thing. He has to pay from somewhere. Any
No,
which
but then
ways,
when
matrimony.
no,
Yes.
I'm just asking that when a PG, when they say debt, there are times when the creditor would, the debtor, the personal guarantor would like to absolve himself of that debt also. I'm just thinking aloud, maybe. You know that
Yes.
there is a matrimonial dispute, and since all my debts have been discharged by way of a repayment plan, hence even my other liability, be it by way of matrimonial liability or etc., or some kind of fine, that also gets discharged. So should you take, as an RP, take some precaution to have a disclaimer?
Priyanka ji,
Yes, sir.
to address exactly this question, this section is there, 7950. The purpose is this only. Liability to pay fine imposed by a court, liability to pay damage, negligence, liability to pay maintenance to any person under law is excluded. It's not even under your purview.
No, sir.
If,
I am trying to ask
right.
you, how should you address it in the repayment plan? I agree that this
I'm
is the
trying to do that.
purpose.
I'll tell you. Okay, I'll tell you what I feel, right? I mean, people can share. There are cases where people are getting divorced because of this. They'll go to court, get a hefty this one, and they'll say, "Okay, bhaiya, now I have to pay to my wife and this one. I don't have any money to pay you." Then what will you do? And somehow, I don't know, maybe I am lucky or not, but wherever I get appointed, they always have 2 or 3 wives. So, and that is actually happening. I mean, at times you feel you laugh at it. What do you do? Whether they are genuine, liabilities which have arisen because the court is giving, or whether they have been created. Now, since we cannot adjudicate, we are not considering it. As far as I am concerned, I am saying I am not even discussing that. Exactly same to that maintenance. There is another thing which has never been discussed here is amount of pension. Now, what is the amount of pension which is allowed? I'm a BT, I'm a PG in cases. He's getting 1.5 lakh pension. RPs get 25,000 per month. The bankrupt is getting 1.5 lakh pension. Now, pension you will say is excluded asset here, isn't it? This insurance policy, pension plan. Now, what do? Do you leave everything there? So these are these are things which will develop. I don't think it's yet developed. Only the house they have said that 10 lakh and 20 lakh has to be excluded. Other than and 1 lakh rupees of that ornament, jewelry, etc. Right? Other than that, pension plan, there is no limit. Liability to pay maintenance, Priyanka ji, there is no limit. Now I don't know. How do you do it? Anyone who has taken care of it, sir? Since we have a lot of IPs.
Can we not put it in the repayment plan where when they're discussing terms of discharge? Can we not put it like the liability of so and so is discharged other than a liability other than those as forming part of excluded debt under 7915 be discharged? Can we not take care of it like this?
In repayment plan, first of all, you can only discharge qualifying debts. This debt is not even qualifying.
It's excluded.
Right? It's any which way is excluded.
Fair enough,
and right, since it's not excluded, it's like jurisdiction, isn't it? Now, if a court doesn't have jurisdiction, how do you do it?
They have to go to civil court. I mean, family court or civil court.
Have to go to civil court. If he can't pay, he will. Let's say, ma'am, let us assume the situation that before insolvency, he was able to pay them 2 lakh rupees per month. Now, after insolvency, he is not able to pay them. Then what will happen? Then he will approach the civil court. He will say, my situation has changed now. Earlier I had this. Now I am not able to pay. Revise it. Obviously, maintenance will be revised. If the court doesn't want to revise, they'll put him in jail. If they don't believe that he's right. But it's out of your jurisdiction. You cannot help it when it is so clearly mentioned that section 7915 excluded debt will not become part of this. In fact, people who have not filed claim also, they are excluded. It's not like a blanket CIRP process. Here, people who have not filed the claims which is not mentioned in repayment plan will not get extinguished. So obviously, if those are not extinguishing, how can we extinguish excluded debt? That's not possible. So
sir, may I ask you something?
Yes, Chitkara.
Sir, so what I want to ask is that as you have worked as a bankruptcy trustee, so thing is that we talk about bankruptcy estate, and as per the personal insolvency rules, so like you said that house should be not more than maybe 10 lakhs in the rural areas, or in the municipal areas it should not be more than a 20 lakh value. Or likewise, the jewelry should be the religious jewelry, and certain other things are mentioned over there. So certain tools are allowed, one car is allowed, like that.
Here it is, sir. Yes.
So what is your experience regarding this, sir? So could you vacate the house, which might be the only house they might be in?
Yes.
Or
yes.
what is your experience practically?
Practically, sir, I'm fighting it in district court now in Hyderabad. Imagine I don't even know the Telugu language. Now he has given it to his ex-wife, made an entry in his name. Possession is there. And whenever I visit there, they run away. They close the door, they run away from the backside. Now, how do I
Okay.
take possession? Now, possession, we know that in SARFAESI, bankers is easy, but you have to go to the district courts. Now, district courts are district courts. In Delhi, at least they are online. In Hyderabad, they are not online. Now, from Delhi, I have to manage a bankruptcy case where I have to take possession forcefully with the police assistance. And obviously, there are thousands of legal hurdles they have already created. Now we are taking NCLT's direction that you please give us something. Now, if all of you are aware that wherever public law gets into picture, NCLTs are saying we don't want to do it. Now you do it as a bank would have done. Now, in my view, sir, bankruptcy trustee is becoming like an OL in the High Court era.
Okay.
कि चलता रहेगा
चलता रहेगा.
चलता रहेगा. So that is my experience right now. I'm still filing in Hyderabad. There are like apartments in Banjara Hills. Now they are bankrupt, and there is 3 Porsche which are parked in the parking.
Okay.
Now obviously it's not in his name, company name. Now company is not in insolvency here with me. Now what do you do? So as a BT, one side is saying कि साहब पैसे नहीं है, you allow them 10,000, 15,000. On another side, 3 Porsche खड़ी है सर, हमें सिर्फ स्पेलिंग भी नहीं आती Porsche की. So what do you do?
So
Now that,
it means that they have better legal advisors.
sir, then at times
And they are
बचना बड़ा
defeating,
आसान है.
they are
Obviously,
trying to circumvent the
yes,
entire
yes,
process.
that is what they do.
I told you ना सर 3 शादी कर लो, आप सबको मेंटेनेंस दे दो, क्या करोगे आप? So all those are excluded. So all those things do happen. It's not that it doesn't happen.
These are all practical
Fine,
problems.
bankruptcy is a stigma. Now I don't think, I think it's sinking in. Abhi bankruptcy bhi stigma nahi hai. So people know that it's a fresh start now, right? Recently, like after this bankruptcy, one of the matter, NCLT Delhi, they have allowed for the person to travel abroad. वो 141 में, because if the person has to travel abroad, that section 141 NCLT, you have to take approval. Now imagine you are bankrupt, you have money to travel abroad. Obviously they would have given a story ke I'm getting a job somewhere in so and so company, in this, that's why you allow me. So that happens at times. You say, fine, what can you do? Now you had his assets, you have taken over all his assets, whatever practically and feasibly in the public domain, you'll take it over. Whatever is not there, hidden, benami sampatti, I mean, our income tax departments are still after their life for ages. What can you do in 6 months, sir? So whatever you can do is what is available on the paper. By one name, I'll tell you, this is not even bigger problem. Now every people now they write their name as Karan Johar, right? A Karan Johar becomes Karan Johar just by one. Now you find it out. How will you find in so many registrar codes? How do you identify asset of the person?
So, Rana ji, काफी सारे, so in many of the cases I have seen that, so wherein my CIRP is going on and various other PG applications are filed. So I do see that whatever house, maybe a single house is there with the PG. So that is already, because they have given that very personal house in the asset liability statement to the banks, but that is not mortgaged to the bank. So what they do is they transfer that very house to some third party or maybe a mama chacha like that. And when the personal insolvency started, you do not find any asset in their name. So what should one do in such a scenario?
Can't help you, sir. How will you change the law? Like the example I was giving you of Hyderabad. Now this person has given it to his ex wife, right? Ex-wife. It's not registered. So if the asset is in my name, it's not, the conveyance deed is not yet done, then we can fight it out. If the conveyance deed is also done, what will you do now? You tell me. One option is you fight it in the civil courts. If bankers are ready to support you for that, fine. See, section 138, Kashi ji, 138 says 1 year bankrupt will be free. It doesn't say bankruptcy trustee will be free. हमारे लिए 3 साल 4 साल doesn't matter, and that is why I said it becomes like an OL in the high court era. वो आज भी 30 साल पुराने केस चला रहे हैं वहां पे. So PT, that's why I'm saying 61 experience only, sir. And right now I think we'll have I think I've spent too much time talking and instead of going through the PPT. But so 5 o'clock is happening. So 60 experiences, and one of since as I said I'm sitting here, my experience is taking over through normal civil courts. It will take its own sweet time. Then it is no more an IBC. It is IBC only when NCLT gives me clear answer yes or no. That fine, you have it, 238, everywhere we survive. Now we don't survive over PMLA, we don't survive over GVAT, we do not survive over EPFO. How will we survive over constitutional courts? So even there we will not survive then. So that is about to come, sir, next week. That is listed before NCLT for argument. Let's see whether they allow us to take over the asset, or they'll say no, first you fight it out in the district court. All that's a practical thing which I am facing right now. Sapanji, are you also facing such issue if you are still here? I think so. He's not here. Okay, so maybe we'll discuss it, at 5:15 if the times allow. 15 minutes. Let's go through. Can a guarantee invoke before claiming the same? Answer is yes. Guarantee is totally separate than the guarantor. And right now, if you look at the law, it seems like it's easier to invoke a guarantee than getting a 7 admitted. So, guarantee is totally separate, totally independent. Whether you have claimed from the corporate person or not is immaterial. As long as you're invoking your guarantee in the right fashion. So it's Vishwa Kumar Agarwal, Piramal Enterprise, totally separate, no problem. Jurisdiction, I think we have already done. Pecuniary, which is the location wise. In this also, let's say you have given guarantee to 3 different CDs. Now, where should it go? And both CIRPs are going on. Let's say one is going on in Mumbai, one is in Delhi. Where will you file? You can file wherever you want, right? So as long as it says pecuniary, it will be transferred, right? Obviously, appellate we are aware of. Lalit Kumar Jain case, I'll not get into it because everyone is aware of it. Lakshmipat Surana case also was important here, where they said harmonious, purposeful, purposive construction should also always be maintained. This was Athena Energy Ventures. Athena Demway is one of the case where there is more than 100% recovery in CIRP. I hope people are aware of that case. Admitted claims were only 500 crores and the plan has come for 650 crores.
Great.
Okay, so our Mr. Garg was there. He was RP, and unluckily I was the first SRA in that company. We lost 5 crore because we could not pay rest of the money from Sikkim government. But yes, that is one case where above 100%. People keep talking that haircut, this and that. No haircut. Athena Damway, 1200 megawatt project in Arunachal Pradesh, 650. And it has settled after 6 years. It took 6 years. But fair enough, in 6 years, more than the admitted claim, much more. So creditors are happy. Role of insolvency, yes. So one thing I would like to bring here to all our IPs is we don't have to become Rambo when it is resolution plan stage. You are only a facilitator. There is no coercive step. In PG, you are only advisor. You will only tell them what is excluded, what is not excluded. You can make your plan accordingly. You don't have to fight. You don't have to take over the company. You don't have to go to his house. Don't go there at 10 o'clock in the night. No need. Appointing valuers, this and that is not even envisaged. In fact, this person can also remove you. You know that, right? The personal guarantor. That means you ought to remain in the good books, isn't it? So no coercive steps, no Rambo fighting, simple process, 4 reports, 99, 102, 112, discharge, 106. Not much. And that is why banks are saying we'll only pay 15, 20,000 per month. Will not pay you a decent salary. So that is one role of IRPs. But as I have given you example of my case itself, there is a possibility of 100% recovery. Also, if you are doing decent, I'm sure it will help. Now, subrogation. Okay. Now, subrogation is, we know subrogation is getting into the shoes of the person for whom you are paying the debt. So, subrogation is allowed, but not under IBC. In IBC, unless everything is paid, you will not get. So there were cases when they said, okay, we have paid 80%. Now, can I become 80% that can I become a creditor? No. So subrogation is allowed only on 100% payment. Before that, it's not. We will leave it. Okay. NI 138 is that check bouncing case. Even on those, now NCLTs are, and I think even appellates are saying that 138 liability will not be absolved by insolvency. IBC is not to protect them from all these. Only the company will be absolved if Section 14 is there. Otherwise, this moratorium, etc., will not work on them and they can still be prosecuted.
Sir, one thing. Sir, Mr. Rana, you said that subrogation will be allowed if 100% debt is paid. So I think
only after that you talk, yes.
No, but thing is that let us say if money is not fully received under CARP and the balance money, or maybe like if personal guarantee is invoked prior to maybe
Yes.
insolvency, so that is also
Yes.
one thing which can be done. But thing is
Right.
that if money is being recovered from the personal guarantor and if Section 7 application doesn't yield the full money, so that balance
Correct.
amount will be recovered from the personal guarantor. So how will the subrogation be there? So let's say 100 is to be recovered, 70 is recovered from CIRP, and 30 is being
Then
recovered
obviously
from.
30 remaining, sir. There is no double dip. We never said double dip is all allowed.
So in that case, subrogation will not be there, obviously.
No. So subrogation is something I have paid for you. Now the personal guarantor says, now since I have paid your money, can he file Section 7 against the company?
Is it
the company will not
allowed?
be there.
That is what I'm asking.
No, he cannot, sir. That's what I'm telling you.
company will not
Unless
be
you
there.
have paid full. So you get this subrogation only when you have paid full. Let's say this person has paid full for against the company.
Okay.
Then why not, sir? Then what will stop him? Okay. Till now we have not received those cases, but in my humble opinion, why not?
Sir,
Subrogation is a statutory thing. Section 140, Indian Contract Act. Why will it not be?
So you're saying you
Guarantor? Yes.
you can file subrogation against SRA who succeeded.
No, sir, SRA is a totally new thing.
New thing.
And subrogation is something else.
Oh,
Subrogation is I am paying on your, suppose you had to pay to, Chitkara Saab, 100 rupees, right? And he is supposed to give you a car against that.
Okay.
Now I pay on your behalf 100 rupees. Should I not get that car now?
You should get.
So that is subrogation. But since I have paid for on your behalf, why should I not get that right? I will get that right. That is subrogation.
But sir, in
But
IBC, that right is not granted actually. So as per the
I'm not denying, sir. It is
case,
here, sir. It is here, sir.
No.
Guarantor does not enjoy the right of subrogation under
Yes,
IBC.
yes.
Anklet explained that guarantors cannot exercise this upon in contract laws because it was till full payment is made. It is not there. Yes, it's in fact in the slide itself. I'm saying, I'm agreeing with you. Subrogation right is not there.
Not there. Yes.
Not there till full payment. Fine. Okay.
Sir, I have one query.
Yes.
Sir, a personal guarantor case was filed after 2 years of CIRP.
Yes.
In that case, interest will continue to accrue on the claim of creditor. Like if 100 rupees claim was filed in CIRP and PG was initiated after 3 years, for example. So claim amount will increase now after it will include the interest accrued in 3 years. Or it will be
Fair
100
enough.
only.
Good. No. I got your question, sir. Anybody else would like to answer this before I try and answer? How others are treating it? Because there is 14 moratorium for CIRP.
Yes.
There the interest stops on admission date, right? Insolvency commencement date. But does it stop against the PG also?
No. The creditor
Mahinderji
can
is saying
recover
no.
up to the date.
Sir,
Okay, Mahinderji is saying no.
Sir, in
Amirji is saying.
Sir, in a liquidation process, the PG initiation happened. So what happened? The creditors, they submitted claim and computing interest up to the date of admission of the PG in the court under section 100. So that interest is applicable, I think.
So Amirji is saying yes. Mahinderji is also saying yes. Anybody saying no?
Sir, according to me, the personal guarantee itself should not take place after 1 year of,
Whatever
say,
that
I
is
mean,
demanded
CRP.
from the corporate debtor, I think to
In one
that
of my
extent they
case, I have paid up to date interest.
You have admitted up to date interest. Okay.
Yeah, up to the
Okay.
date. On the date of payment of the balance amount, which could not be recovered from corporate.
Liquidation commencement date.
Not liquidation, sir. This one. PIRP. So
Resolution
PIRP
plan,
commencement. Yes.
resolution plan was approved. Balance amount was recovered from the guarantor till the date of recovery, including interest also by State Bank of India.
Okay, so Mahinderji has taken that route, and anybody else is taking another route. That's what the question is. That right?
Sir, in the
That's
distribution,
only till CIRP. So I think one of us said that
sir,
it should not be.
In the bankruptcy trustee process, when the distribution comes, there is a
Yes.
provision for paying the interest for the remaining period if the surplus is there.
Which will never be there. Okay. Sir, it will never come. I mean, that stage, I don't think it will ever come, because if that could have come, then we would not be here. So that's a pretty very, very rare situation.
Sir, actually,
if that comes, then why not? Yes.
This is just opposite of liquidation process, sir. Liquidation process, as on liquidation commencement date, the liability is crystallized, and the liquidator has to pay if the money is sufficient up to that amount only, not beyond that.
No, sir. So question was very clear that this liability has arisen because of a CIRP of somebody. Now he's saying till when this should be accumulated. So sir, in my humble opinion, answer is it will continue, because liability is of whom? If the liability is of personal guarantor, it will continue till his admission. For CD, it will continue till its admission.
Coextensive liabilities. No.
Coextensive. These are two different separate silos. Only difference is that if there you have recovered 70, reduce that 70 from 100 from here. That double dip cannot.
Can we climb more from the?
Oh yes, it can be 110. Let's say by that time it becomes 110. Then 110 minus 70.
No, can we climb more from the personal guarantor than what we are climbing from the corporate debtor?
You tell me, sir. Good questions. Yes. Why will you do that? On what basis?
No, that is, I think we are not supposed to climb more than what CD is due.
Ajay.
Or otherwise, sometimes bank guarantee will be a limited amount of to a limited extent also. Suppose guarantor is giving only to a limited amount, we can climb only for that portion.
Yes. So it's up to what you have claimed. Suppose CD had to give 100, you may say I will only guarantee 40 or I'll only guarantee 50. Nobody will say that fine, you take a loan of 100, but I'm guaranteeing 150.
No one.
I mean, that does not even make sense,
My
right?
resources should have.
So it will be at par with it. It will definitely not be more than that, unless, as we are now discussing, the interest portion gets added. So maybe because there you started CIRP 3 years back, there you claimed only 100 rupees plus 10 rupees. By the time you come to PG, it becomes 100 plus 115. Now that is a possibility, isn't it? Only in that case. Otherwise, you can't take more than that.
Sir, suppose in a scenario where the claim is admitted by the liquidator and the liquidator could able to pay the full amount to the financial creditor, whether the financial creditor can initiate for the remaining period, liquidation commencement day to till realization, the interest portion against the personal guarantee? And can initiate personal guarantee?
Sir, this hypothetical situation you are actually facing or you are creating?
Yeah, I am facing, sir.
You're facing. Okay.
I have
Then
similar
it's
case, sir.
fine.
I have similar case.
Yes.
In my case
Yes.
also, a principal amount is paid in and only interest component was pending.
Okay.
That interest also includes interest accrued after initiation of CIRP.
Okay. So against PG, sir, it will still pending till
Yes, sir,
100.
yes. My
Yes.
I also treated accordingly.
In my view, I think this is the right way, because luckily bank have two lives. Like we play video game, right? So in video game, if one life you get down, the other person, second life you have. So first one, they could not get all their interest. They still have one more life to try it. So in my view, sir, Amirji, what you have done is correct.
Sir, one more thing. Sir, repayment plan not received. So in that case, also reports under section 106 and 112 are mandated to be filed, or
Nowadays, yes. Nowadays, yes. Earlier, we used to straight away file that no need of COC, because see, there is no plan. What will you do with COC? Right, isn't it? So we used to file straight away. Now what happens is IBPI said, no, you have to do a COC. Now, if you have to do a COC, now I'll tell you why we do this. In where I act as an advocate, we file a report under 106 within the timeline, so that IBPI doesn't come after us. We file a report saying there is no plan as yet. We are doing COC after 14 days on so and so date. If before that plan comes, we will discuss it. If not, we'll come back to you.
So that COC has to be done within 120 days, or it can be done later on after 120 days.
Why you want to do after 120 days?
Before 120 days, no?
Sir, Rambo बनना ही नहीं है, sir. Simple. Law says 15 days इतना करना है, 106 की इतने दिन में फाइल करनी है, फाइल कर दो. प्लान नहीं है, लिख दो. प्लान नहीं आया, we are doing a COC in 14 days till 14, 20, whatever you want to give. If I get a plan before that, we will do voting. If I don't get a plan, I'll come back to you in 114. Go back to 114 if you have got an approval. If you have not got an approval, go accordingly. Story over. Take liberty. File in 122, 123. PG case, pretty simple. And keep it simple. Try to keep it as simple as possible. I think
Ramesh,
we
there is
already
one
have
more person.
5:15.
There
Chitkara
is
ji,
one.
yes.
Ramesh, there is one another person, Mr. Akhil Ahuja. So he just want to share his practical experience.
Oh, please, sir, please, yes.
So this release of
Uh,
personal guarantor, I mean, we have not.
सर अभी टाइम खत्म हो गया, अभी चित्कारा जी मुझे भगा देंगे.
I had one practical issue which
now
I'm
we have-
facing, and I was actually expecting an answer here.
So Akhil ji, would you like to share your
Yeah,
personal
sure.
experience?
Yeah,
I
sure,
think let
sure. Hi,
Akhil
hi
ji.
everyone.
Yes.
Hi everyone. I hope my voice is clear and loud.
Yes,
It
yes,
is.
you are audible.
Sorry, actually, I'm just on the way, so there might be some disturbance. I will try to minimize it. So Chitkaraji, someone was asking a question. Let take up the discussion from there only. Let's see if I can add value to the question, to the answer to the question.
Please
Sir,
go ahead.
sir, release of personal guarantor. Now, see, now I have a practical case where the company is not even gone to CRP. The person, I
Right.
mean, personal guarantor want to get out of the company. I mean, like the other people were making him out, but the bank is not allowing him to release the personal guarantee at any cost. So what?
When you
How do
mean to
we
say
get out
bank
from
is
the
not,
personal guarantee?
so when you say bank is not allowing him to get out of the personal guarantee, the bank is not releasing the personal guarantee.
Bank is not released the personal guarantee. It has become NPA very recently only.
So
They have not
the
filed a
simple.
CRP.
So simple. You are saying the Section 95 process is not applicable to this personal guarantor, right?
Yeah,
Right,
now
Mr.
the all
Prabhat?
other people are ready to release his personal guarantee, but how do we get out of this personal guarantee issues? Like
Simple. It's a negotiation and the OTS with the banker. No other route. You have given a personal
but
guarantee
if
to
there are
someone.
parallelly some people are going for CRP. Already we know that somebody has already filed CRP. I mean, not this bank, but other banks. So
Let them go, and then your client can file Section 94 application himself also.
Yeah, hello? Hello?
Ramji, you are mute.
Hello, can I ask my question? Hello?
Yeah, please.
Yeah, actually, one of my cases, what's happened, I submitted the report under Section 105. Okay.
Right.
But there is a creditor who didn't submit their claim within that last date, as per the advertisement.
Right.
So they
Right.
filed application before NCLT, and NCLT directed to incorporate their name in the list of creditors. So I have
Right.
done that, but should I again submit my report under 105? It is already
Yes,
submitted.
sir. Yes, sir. Definitely. First of all, do you have the repayment plan or not?
No, no repayment plan. No repayment plan.
No. Okay, so are you expecting to receive any of the repayment plan?
No. No.
If you are not expecting it, it is only about the updation of the list of creditor to the Honorable NCLT. Right, sir?
Yes, yes.
Either you can do revision filing, or you can also opt once you're going to file your final report where no resolution or repayment plan has come, you also can give the updated list of creditor there also.
No, I couldn't get. Come again. Sorry. What you said?
So definitely you're going to submit your final report also with the Honorable NCLT that the
I have
no
already
repayment plan has been.
submitted my report on 105.
Then
But I have
file
mentioned
an
there is no.
additional.
Now what's happened? One of the creditors, they filed their application, and NCLT directed to incorporate their name in the
Right,
list of creditors only.
File an additional affidavit with the updated list of creditors.
Okay.
In fact, Parthaji, what Akhilji was saying, I think is bit better instead of, wasting time here and there. File your 114 if you have no plan. Straight away said that there is nothing. In that you can write that fine, this claim has also come. Because it's not going to help any which ways. Your additional, what is it going to help? Since you have no plan,
yes.
If you had planned, it would have been something different.
No, that's
right?
okay. No plan, no plan.
So then file your 114 straight away, get released, you also go home.
Okay. Thank you.
So just a technical question, may I ask? I just got confused
Yeah,
over this
please.
period of time. If a 106 is to be filed only if, to my understanding, please correct me, is
Yes.
when the repayment plan is received and approved. Otherwise, 112 is applicable, if I'm not wrong, sir. I mean, even if the
Yes.
repayment
Yes.
plan is received and it is not approved, then a 112 is applicable. 106 is applicable only if it is approved. Is that correct, sir?
No. I'll tell you why. Okay,
So
let's
are
keep
you
it
saying
very
a
simple.
106?
Sir,
I'll
may I
keep it very
request,
simple,
may I
ma'am.
request everyone?
99. Okay,
May I
Akhilji,
request everyone
maybe would
that
like to answer
let us
this.
take the
Devraji,
question
please continue. Devraji, please continue. Please continue, sir.
Nee,
let us
Akhilji,
take the
sorry, ma'am.
question answers.
I get, swayed with
No, no,
the.
no, no. Please continue, sir. You will give me
Okay.
better answer.
So 99 report is first report you file. 100
Right,
is your
sir.
admission.
Right, sir.
After that, you are supposed to get a plan from this person. Now
Right, sir.
that plan, you just have to say whether it has reasonable prospect or not. Correct? Now, and that is 106 report, correct? Name is
Right,
105,
sir.
but it is filed under 106. So you will say
Yes.
that fine, I have report X. It has reasonable prospect, yes or no, and I'm putting it to the COC. I'm doing my COC on X date. If it is approved, fine, we'll come back to you. Otherwise, will not come. Otherwise, will any which ways will come back. There was a time when we were not filing on 106. I was filing 114 straight away.
Right,
112.
sir.
Now, IBPI regulation says you have to do, RP has to do the COC meeting. Even if you don't have a plan.
Excuse me to interrupt you here.
Yes, please.
Having a COC, to my understanding, how is it tied up with a 106 report? I can have a COC and still file a 112. Because in COC 17A regulation, I am having a meeting of creditors where the plan is approved, not a plan is put before the COC. The COC in its wisdom decides not to approve or decides to have another MOC. Then again, I mean, it's 112, I think, which comes into play. 106 does not come into play
Fair
at all.
enough. Okay. Fair enough, ma'am. You are saying I don't want to take efforts of putting 106. Correct? Agreed. It does not say that
So
106
not
you have
effort,
to
not
file.
applicable.
Okay. Anybody else here who has filed straight away 112 instead of filing 106 also?
Sir, this is Balasubramanian
Balaji,
IP.
yes.
Yeah, Balasubramanian. Sir, actually, I would like to bring your the forum's attention to 19th May 2025 amendment to Regulation 17B, non-submission of prepayment plan, issued by IBBA, which says where no prepayment plan has been prepared by the debtor under Section 105 of the Code, the resolution professional shall file an application with the approval of creditors before the IA, intimating the non-submission of repayment plan and seek appropriate direction. Hence, where there is a repayment plan or no repayment plan, we have to conduct COC meeting, sir.
No, sir, we are agreeing to that. We are not disputing on.
As
See,
per me
Priyanka
also
ji has a
report.
very good question. Why do I even need to file 106 when there is no repayment plan? Ma'am, for Priyanka,
Yes, sir.
in my view, 106 is more like consider it as a progress report, which you are telling NCLT and keeping IBBI also at bay that I am filing, I have done my entire process.
So a progress
If
report
you feel
was
like you don't need to file, it's up to you. I do agree what you are showing that yes, it's not that mandatory. It doesn't say that if it is not there, then also you have to file. Because our code never even envisaged that they will not file a report, the plan.
Okay.
In fact, if you
No, sir,
see,
there is
everywhere they
another.
say file a plan, they will file a plan. It was an assumption. But what if they don't file a plan?
No, sir, there is another thing which I think is a deterrent in 106, which is
Yeah.
in 106 2B, if I'm not wrong, the RP has to say that it has a reasonable prospect of getting approved. The minute the RP undertakes to say that in his or her 106, somewhere you're also held accountable if it goes the other way to justify your previous action. Hence, 112 is always advisable, is preferred in my opinion to 106. 106 comes into play only and only if it is approved. Am I correct, or is this contention?
Okay, I'll tell you. In 106, in 106 subsection 4, it says the date on which meeting is to be held should not be less than this, should not be more than 28 days, correct?
सर
Now,
लेकिन
where are you
ये बना था 2016 में. ये regulation has come into effect on 31st of January 24. Hence, it is
Correct.
not, there is a retrospective you can't say an amendment, but there is a retrospective change by way of regulation, and hence a COC is mandatorily required by way of 17A regulation.
Ma'am, that is what I'm trying to convey. My viewpoint only that 106 is more like a progress report where you tell that if plan has come, it has a chance of succeeding or not. Or if no plan has come, you will say, fine, no plan has come, but I have spoken to this person is saying they might give a plan. If the plan comes before that, we will be discussing in the COC. Or and any which ways 112 तो हमें आना ही है. We will be in front of the milords in 112. So 106, I consider it as a more of a progress report where you are informing if plan has come, not come, or what the RP thinks about.
Okay, sir. I mean, I have a slightly different perspective, but however, I respect the views here. Thank you.
But sir, here just
Akhilji, you can please take it back.
I want one more clarification.
So I
You
would
say-
request, I
you
would
say
request the
in my-
participants to please take it up, take the queries in the question answer session. So let us continue with this very session as of now.
Okay.
So maybe if Mr. Akhil can add some value regarding his personal
Yeah.
experience.
So thanks, Sandeep. So I would prefer to touch base more of the practical insight instead of the NCLT procedure, which is also very critical on the grounds. I would like to share few of my experiences just to highlight what are the conversations are going on into the person insolvency matter, and we definitely want to take the insight back from the audiences also. So my first question, this is very clear. While we do the resolutions for the corporate entities, the plan should be unconditional. But while we're going to come up with the repayment plan, the repayment plan always have conditions. That conditions are generally be favorable to the guarantors, which required a negotiation with the bankers. Now, tell me one thing. In one of our cases, the corporate debtor is under into the insolvency. The resolution professional filed so many PUFE applications against the suspended board. One of the COC member initiated the personal insolvency under section 95. Now the repayment plan that we got also requires settlement of the PUFE applications, which was filed by the resolution professional. Now I would like to take the view of the audience. What do you think? Whether it would be possible that the repayment plan also provide a condition that upon the fully implementation of the repayment plan, all the PUFE application will also consider as fully settled. Yes, please.
I don't think so, sir. 184 में तो ये पुफे ये सब जब आता है तो पुफे अगर खाली if it is not fraudulent तब तो हो सकता, नहीं तो 184 ट्रिगर हो जाएगा सर. 184 को कैसे आप मिटिगेट करेंगे?
So tell me, let's see the transaction. It is not under the insolvency law. It is under the normal conversation with the bankers. Can the banker do an OTS transaction in the fraudulent account?
तो I
सर
think
फ्रॉडुलेंट माने क्या है, क्या फ्रॉड कर रहा है, उस पर डिपेंड कर रहा है,
सर
उसको
फ्रॉड तो
ओटीएस
किसी भी
का।
चीज का हो सकता है ना, फ्रॉड तो किसी भी चीज का हो सकता है, फ्रॉडलेंट सेल ऑफ द प्रॉपर्टी, फ्रॉडलेंट डाइवर्जन ऑफ द फंड्स, इट माइट बी रिपोर्टेड टू द आरबीआई for the master circular, it might not be reported to the RBI, depending upon the any procedures that is required to be followed under the RBI guidelines.
सर इसमें तो ऐसा है ना कि
the point that I'm trying to make, see from the perspective of the personal guarantor, first the banker has a claim of an X amount on the corporate debtor. Same amount of the claim has been filed in the personal insolvency also. And then there could be a potential future liabilities in the form of a proof application. Now the guarantor, if he doesn't get the entire immunity from the payment, what could be his benefit to give a repayment plan for a limited extent? So we have a detailed analysis, we have taken a legal opinion also, and the answer that what we have concluded, yes, the proof application can also be settled along with the repayment plan. But yes, it's a commercial decision of the COC at what value they want to settle it. And while we are doing a research, even in the Western countries, specifically the UK, within the CRP, before filing any PUFE avoidance application with the Honorable NCLT, the rights are given to the respondents to come in the COC meeting and try to settle this PUFE application. The objective is not to have unnecessary litigation. If I did something wrong, can a compounding be done? The answer is yes. I diverted some funds. Can I come and do a compounding with my lenders? The answer is yes. Now this is something has not been written into the insolvency law, but this can be done. Yes, we have concluded. Yes, this can be done. Yes, ma'am. Any question that you have?
So, Mr. Akal, I think you have rightly said that this is the commercial. I think this is the commercial wisdom of COC to see if they get certain money out of this very PUFE application, and that can be settled with the personal guarantors. So, I think this can be approved by NCLT.
Yes, definitely. We are
Mr. Rana, what is your view?
That.
My view, sir. So first of all, assumption, and Akhilji will also confirm, COC has to be same in both the cases.
Yes.
If it is different,
100%.
then obviously this goes for a toss, right? So if it is the same person, they are sitting, same people are deciding on repayment plan also, same people are deciding on resolution plan also. Then yes, it can be done. Reason being, earlier we were saying same RP cannot be appointed for both the matters. Now regulation says same RP can be appointed for CD as well as the PG. That means even our code says that if it can be settled at one forum with one set of people, then why not?
Right, sir.
But Akhilji, as I think, if there is one extra person in the COC, I don't think this will happen. Secondly,
There is a
as I
solution to
said,
that also.
so that's my point of
So,
view.
but I do think that there can be the similar set of people who might be there in the COC. So obviously, different claims or additional claims might be there in case of personal guarantors.
Similar or same, sir, very different, sir. Here we still have three-fourth of the majority required. There we only need 66.
Right.
So even that is separate. So if it is similar, will also not work, sir. If it
So,
is
sir,
exactly same, then only it will work. Otherwise, it will be challenged and overturned.
तो सर एज एन आरपी वुड यू सजेस्ट द वे फॉरवर्ड इज कि PUFE सेटल हो गया बट यू शुड स्टिल कवर दिस एस्पेक्ट ऑफ रिपोर्टिंग टू NCLT and IPPI because as an RP
You will have to, ma'am. You will have to.
Yeah, that
Why
is
not?
what as an RP I have to cushion myself for it.
Yes, 100%.
And
In
it
fact,
should be
tell me one
recorded
thing,
in the MOC?
ma'am, Priyanka
Yes,
ji,
sir.
one more thing.
Hanji.
Why are you saying only reporting here? If you have filed a PUFE application, that must be pending at NCLT. File an affidavit there, withdraw it. When is NCLT saying that PUFE cannot be withdrawn?
नहीं
Is
नहीं
it-
सर, ये अपने अपने लोग एज एन अडेंडम टू व्हाट मिस्टर अखिल जी सेड कि इंटरनेशनली फूफे का अगर कोई आता है तो दे से दैट द रिस्पोंडेंट कैन बी अ पार्ट ऑफ द सीओसी सो दैट इट डज नॉट इवन गो टू एनसीएलटी और द एडजुडिकेटिंग अथॉरिटी। सच
हमारे
बीइंग
यहाँ
द
जाना
केस।
पड़ेगा,
नहीं
हमारे
सर,
यहाँ जाना पड़ेगा।
आज के दिन हम नहीं, तो माने आप बोल रहे पहले पुफे फाइल करो, फिर कॉम्प्रोमाइज करो और फिर इंटीमेट करो। दिस इज द प्रोसीजर दैट यू आर सजेस्टिंग, इज इट?
So I am not suggesting any procedure. I am
yes,
just
yes.
giving an insight that the personal insolvency is very different context, and there could be so many variation in streams that is going to be coming out of the repayment plan. This is just one of that variation. I am giving an example.
Okay, sir. Thank you.
Okay, so now I think that now time has come. So I would request Namrata ji to take over maybe to moderate the session.
Thank you so much, sir. I guess it's already very well moderated.
Yes. I think
and
this is going great. So a
yes,
lot
it's
of
going
good discussion is there, and the involvement of I think many IPs is there, and this is very interesting.
Absolutely. In fact, the questions that are coming in my mind before I can even form it has been answered. Even in the chat box, if we can see, there are questions about PUFE, which we just, I think we've attended to it. And there's a question on repayment plan under section 106 and 112 discussed in detail. Mr. Shekhar Sen Gupta, PUFE relates to the assets of the CD, whereas in PIRP relates to the assets of PG. And moreover, there is no applicable section of PUFE in individual resolution process. Only in bankruptcy, there is PUFE and no F. So,
Yeah, fair enough. So definitely, whether the resolution professional can file the PISA application in the personal insolvency process, the answer is no, since there is no responsibility lying on the insolvency professional either to unearth or to file the appropriate application. That can be filed only into the bankruptcy process. But yes, generally what happened when the corporate debtor into this insolvency, the lot of such future application, the lot of diversion of funds that has already been identified, that can be used, and even the identification of the new assets can be done in the personal insolvency, and that can be used as a tool for a better negotiation. But no filing can be done of the future in the personal insolvency. Right, Mr. Shekhar?
Mr. Shekhar, I do. Mr. Rana, anything from your end?
Yes, thank you.
Akhilji, RP doesn't have to be Rambo in personal insolvency. Simple. No
Right, sir,
buffet,
right.
nothing.
Agreed. Right.
Live your life happily. Bankruptcy trustee, you do whatever you want to do.
Right, sir.
Sir,
So can you explain the meaning of the bankrupt is discharged in 1 year? इसका मतलब क्या होता है, sir? 138, if I'm not wrong.
138, I have filed this week, ma'am. Okay, sir, Akhilji, please.
See, tell me one thing. There is one personal guarantor. His CIBIL score must be very low. There are a lot of liabilities must be appearing in his CIBIL score. The objective of the law that this person could be revived. If his CIBIL score won't improve, if it is liability keep on showing in his CIBIL report, how he could able to revive? वो जहां भी कोई नया business करने जाएगा, नया loan लेने जाएगा, that CIBIL report is going to be referred back. Once the discharge order is there under 138, I believe that discharge order will be utilized by the personal guarantor to revive his CIBIL report. That all my prior liabilities has been settled as per the insolvency law, assuming the plan has been implemented. Or there is no plan, then under the bankruptcy, there is a by default the bankruptcy discharge after 1 year, so that is all liabilities can be written back and new fresh financial life can be started.
Yes.
There are going to be a lot of challenges on the ground to do this. And even as of today, lot of bankers are not going towards the bankruptcy. The banker says, okay, we started the personal insolvency. It didn't get a success. Hold on. We don't want the bankruptcy. We're gonna to keep on continue all the DRT applications, all the other remedies that are available in the civil court, and the banker want to continue that application instead of going into the bankruptcy. Because when the bankruptcy start, the PG is going to say, give me the discharge order, 1 year is gone. Whether NCLT is inefficient, whether IP is inefficient, whether the creditor is inefficient, give me the discharge order. Yes, sir.
Akhilji, in that case, there is 122. He
What
can
122 says, sir?
He can go directly, start my
Yes,
bankruptcy.
he can go directly. He
So
can go
how can
directly,
you
and
stop
the
somebody?
bankers
How
are
can you-
realizing this after 3 years of filing the personal insolvency. Right, sir?
Yes. Certainly. So that is being
Sir,
realized
in
now.
one of our case where there are 7 to 8 consortium bankers, right? 7 to 8 bankers constitute the entire industry of the banking industry these days, right? They approve the agenda for the bankruptcy, and after the approving of the bankruptcy agenda, they say, no, we want to revoke back this agenda. हमसे गलती हो गई. We don't want to go into the bankruptcy. The point is, the law is very new. Everybody is trying to understand this law. The ramification of this law is very, very, very significant. And I always say that these are the debtors' law. These are not the creditors' law.
Thank you, sir.
Right, sir?
Thank you so
अगर
much.
यही है तो फिर कोई भी आदमी रीपेमेंट प्लान देगा ही क्यों? बोलेगा पहले आईआरपी शुरू करो, इंसॉल्वेंसी, और हम कुछ नहीं देंगे, तुम बैंक्रप्सी 3 महीने के अंदर शुरू करो, नहीं करोगे हम अपने लिए बैंक्रप्सी शुरू करवाएंगे, साल भर में कुछ नहीं होगा, हम हमारा डिस्चार्ज ऑर्डर हो जाएगा, हम फ्री हो जाएंगे, अब मेरा डीआरटी भी कुछ नहीं कर सकेगा।
See, ma'am, see क्या होता है? If you see ना, whenever how we see the failure as a society, if my child not get a good marks in the 8th standard, मैं उसको क्या बोलता हूँ? मैं उसको बोलता हूँ तो रूम में छुप जा, let not any of the relative ask your performance, और मैं उसको बोलता हूँ don't worry bro, let's move on. It's very the individual perspective. This person guarantor is gonna to take it. Whether bankruptcy is a stigma, it could be yes for someone, it could be no for someone. One of my client is very afraid मेरे घर के बाहर public notice नहीं लगना चाहिए. I will do everything just to avoid the bankruptcy. I will do anything to avoid the insolvency. And there would be other client who says it doesn't make a difference. It's just like any other legal cases. So it's purely depend upon the perception and upon how the person views it and take it. But yes, at the end, it's a debtor law. It's not the creditor law.
Thank you, Abhijit, so much.
Can you
Yes, sir.
can you take some more
Yes,
questions
sir.
which you have received from participants?
So, participants, anybody trying to ask questions, please raise your hands. And I think Partha Sen sir was asking a question. I think he's just joined back. Mr. Partha Sen. So in the meantime, yes, I had a few questions as well, which I had lined up. In the given scenario that this being a very new law being implemented, would you suggest a mediation or a pre-filing mechanism for personal insolvency, sir?
Ranaji, please.
Well, as a lawyer, I don't believe in mediation straight away. Some people lovely believe it. I don't think anybody in, COC we all have worked with, right?
Mm-hmm.
Do you ever think they are ready to discuss anything which is not, I mean, they never vote on something where they have to take a decision. So how do we expect CIR, mediation to succeed? See, even for OTS, they agree only when there is something really substantial, or they feel that everything else is gone for a toss. My personal view, mediation, I'm not very gung ho. People do talk about. My view, no, it's again a waste of time. 94, my applications are pending for last 3 years. 94 doesn't get admitted. And I'm always a staunch believer that why 10 and 94 should take time. Person himself is saying my pocket is torn, I don't have money. अब उससे ज्यादा आपको क्या proof चाहिए? Section 10, you try admitting at Section 10 application, you will know. It will never get admitted. Same way, Section 94, you try getting it admitted. So, I mean, that is already happening. People, my view, ma'am, you asked me, not so gung on mediation. So,
Thank you, sir. Mr. Shivarama Prasad, please unmute yourself and ask the question,
I
sir.
have a small query for the speaker. So, what is the way to handle the secured assets in the bankruptcy? If the creditor does not want to relinquish the secured asset.
sir, they can relinquish on their own. It's okay. Like in liquidation, they have Section 52. They want to do it, it's fine. If somebody has exclusive charge, they do that. They can do it.
But the issue is, if the no action is taken within 30 days, that is
Obviously,
the
then it will come to
problem.
you.
What is
Yes.
the action? Action means is it sale of the asset or any action?
Sir, sale of the asset is the only action you can do. What else you want to do?
Giving notice, suppose the
Sorry,
vehicle
sir, that is
going
playing around. So, okay, you can do playing around and all, but and ultimately you have to sell the asset, correct? So,
Okay.
you 30 days time you have in liquidation, similar. So compare it with that. 53 there, you have 178 here, you have 52 there. Here also, if they want to see, if somebody has their own car, they will not sit in the bus. And bus is the COC where all other are sitting and you are the driver. If they have exclusive charge, they will go in their car. If they don't have exclusive charge, then only they are coming here. And
So,
like in CIRP, they cannot do exclusively. Here also they can't do exclusively. That is why they were sitting.
So, according to you,
when it comes, yes.
according to you, the action is sale of the asset only, nothing else.
Sir, that is your only job, sir.
Yeah. Understood. And
They
one
stick
more
to the
thing,
job. That's what I
And
believe. Yeah.
one more thing, in the case of COC in the bankruptcy, the secured creditor, his voting share is a total claim minus the value of the secured asset. And at the beginning of the process, I do not know because I have the asset has not been valued, all those things. How should we handle it?
Sir, that is where they say, no, you estimate, best estimate, and then with the valuation report, you revise it.
Okay, and subsequently I have to validate.
Yes, obviously.
Okay.
Thank you.
And yeah, one small query, of course, is very simple. This Form F, does it require notarization?
Acha. So if you want to go really like, sui dhaga leke, then get it notarized. Otherwise,
Okay, right,
doesn't
sir.
really hurt, sir.
Understood. That's all. Thank you, sir. Right.
Thank you, Ms. Prasad. Thank you. Mr. Partha Sen, sir?
Namrata, before moving forward, I request Mr. Rana to please stop sharing his screen.
Oh, yes.
Acha, I am audible. Hello, I am audible.
Yes, audible.
Yes,
Please
sir.
go ahead.
Yeah, actually, I just want to raise my earlier question. I said that I have filed my report under section 105, and it is noted by NCLT. Subsequently, what's happened? One creditor, they asked me to incorporate their claim in the list of creditors. So I said it is already late. I mean, you didn't submit your claim as per the last date of the advertisement. So they filed the application with NCLT, and NCLT now directed me that you incorporate that's all. You incorporated their name in the list of creditors. My question, after incorporating their date, I have to submit that 105 report once again. There is no repayment. No repayment plan received till date.
Sir, we have answered this, if I remember.
Yes, this is already answered.
And in fact, as a fellow IP, I would like to suggest one thing here, Parthaji. Last date has no significance. Why will you reject his claim? Why you make him go to
Because
NCLT?
they
Take his
raised the claim
claim.
after my submission of the
अरे
105
सर
report.
again सुई धागा लेके बैठे हो आप. So my question is, his claim will not go away if it is not mentioned in the repayment plan, correct? So you might as well take him in repayment plan. It is in benefit of the
Sir, there is
debtor
no
only.
repayment plan. There is no repayment plan.
Sir, even if there is no repayment plan, 100 रुपए पे भी नहीं आया, 150 पे भी नहीं आया, क्या फर्क पड़ता है? Why
Yeah,
will
okay,
you
but my
make him go to NCLT? That is what I'm saying. So that is where, NCLTs are actually passing strictures against IPs. They're saying why they are making them coming to us where this could have been settled at the IP end.
but sir, if you see the provision of personal guarantee, there is no provision where it is mentioned that the condonation of delay can be granted. I don't know. I mean,
Arre sir, you are
Insolvency
an
has
RP, do it. Hey,
I,
is it
I have
hurting someone? You tell me. I'll tell you, condonation of delay is required when it is hurting someone's interest or it is affecting someone. If it is not affecting someone, they'll go to NCLT. NCLT will do it. On day one, they will do it.
Yeah,
They
but
will
then
not even
how?
issue notice. They will not ever issue notice, anything. So why do you want to do that? I mean,
Yeah,
why
but
can't we
what will
keep
do
things
now?
simple, sir? Yes.
Now,
Now
what
you
I'll
do,
do
just
now?
file your 1-1. Sir, by now your 114 time must have come. So forget
Yes.
106, straight away go to 112 and file it. That's all.
Oh, yes.
Thank you, Mr.
That is the best remedy.
So one last question. How are courts dealing with non-cooperation from the personal guarantor during the process, sir?
The way they are dealing in the other one, but what can they do? I mean, and see, personal insolvency, ma'am, there is no coercion. There is no there is no non-cooperation you can file in personal insolvency. Only in bankruptcy you can do. And in bankruptcy is not giving you asset, what can you do? Whatever you have, you file it. What will NCLT do? You tell me.
So no one has much recourse on this, sir.
You don't have to take him in custody, right? CD, we have to take assets in custody. Here, what do you do?
So, Mr. Rana, so far as I understand with the entire deliberation is that our perspective from RP to in-person insolvency, it has to change. That
Yes, sir.
has
Certainly
to be
it
changed.
should. Certainly.
Yes.
So
Sir, IRP is Rambo who goes on day one and take over everything.
So, Ranaji, you
In
said number
personal,
of
please
times.
don't do that.
So you said number of times that RP should not act like a Rambo. But like Mr. Akhil Ahuja said, that if we find out maybe some other asset which is hidden till now, and that might not be, the bankers might not be aware of the same, or the creditors might
RP
not be
ban ke
aware.
mat karo, sir.
So will
mat
it not
karo.
help in the repayment plan?
Certainly not, sir. Zero.
Okay.
And he never said that. Akhilji is here. I don't think he will say that RP has to do investigation and all. RP cannot even appoint anybody. Look, give me from section 96 till 120. Where does it say I can appoint even a valuer?
So he has
Forget
to work as
investigation,
facilitator only.
SLC. Sir, not even a lawyer.
Facilitator only he has to act like that.
Exactly. He's just the facilitator. 4 reporte banani. That's all.
Yes.
So
Sir,
why
अगर litigation record say if we find out certain asset which might not be,
you don't have to find out. It is
Okay,
his repayment plan.
Sir,
He is saying,
perspective change करना
I
है,
want, sir, exactly change that. आप 6 महीने में BT बन जाओ, फिर जो मर्जी कर लेना उसके साथ.
ठीक है सर, ठीक है, understood.
Resolution में
So
कुछ
I
नहीं
think
करना.
it is this really was. अच्छा नम्रता जी आप close कीजिए पहले.
नहीं sir, वही मैं कहना था. I think the time is up, but it was not sufficient, sir. We need more session on this. Rana sir, I think in fact the last slide also a lot of participants were asking for the release of the trustee. So yes, we need one more session. But this was a very, very good session. I think a lot of participants, lot of brainstorming was done, and appreciate your contributions. Up back to you, Sandeep sir and Parag sir.
Thank you, Ramsa. Sandeep ji.
Okay, so I think this was a wonderful session, and I could see that there was a lot of participation, and people are, so this session might not be enough to maybe cater to the questions which are coming coming from AK-47 rifles of everybody. So we will be requiring another session, and Mr. Rana has to maybe tackle all those questions which might be coming up. So like bullets from AK-47. So now I would request Mr. Parag Singhal to maybe show his gratitude and to offer a memento to our speaker, Mr. Devrat Rana, and also to moderator.
Thank you, Sandeep ji. So Rana, this is a small token of appreciation and our gratitude to you. And a physical copy of this will be delivered at your office in times to come. I mean, as soon as possible. Thank you very much for being here. And moving forward, let me also, yeah, this is for our moderator, Ms. Namrata Nanderi, for moderating this session in such a wonderful manner.
Thank you.
Thank you very much.
Thank you so much.
So thank you all. So now I would like to invite our IPNet West team. So if they can announce the next webinar, they might be organizing.
Namrata, please.
Yes, sir.
Namrata,
Thank you, sir.
you go ahead, go ahead. You are there. आपके मुंह से लोगों को याद रहेगा. मैं बोलूंगा तो भूल जाएंगे.
तो पहले चीज बोल देती हूँ. बहुत सारे रिक्वेस्ट आए चैट पे. राणा सर, we need the PPT. उसके बाद I'll make the announcement. So we would like all of you, please participate in the next upcoming IPNet webinar. Join us for the insightful session as we delve into the world of enterprise valuation, focusing on key techniques, regulatory frameworks, and landmark case laws shaping valuation practices in India. So next Saturday, 2nd August, see you everybody at 4 o'clock. Thank you so much.
Moreover, Namrata, I just want to add here that I think regarding the slides, I think Mr. Devrat Rana might not have shown just maybe even the 10% of the slides he might have prepared. So there have been a lot of questions, and he could not actually go through the entire set of slides he might have prepared. So we would like to have those that very presentation with us, and everybody will learn from it. So now I would request Mr. Parag Singhal to actually extend his vote of thanks.
Thank you, Sandeep ji.
On behalf of IPNet.
Thank you very much, friends. It's indeed an honor to extend the vote of thanks for today's webinar. Today's event has shed light on the complex path of personal bankruptcy. First and foremost, I extend my heartful thanks on behalf of IPNet to Mr. Devrat Rana, our distinguished keynote speaker, for his profound insights and practical perspective of the subject, which has broadened our horizons and helped in understanding the new and evolving domain of personal bankruptcy in India. Thank you, Mr. Devrat, for sharing your time, wisdom, and experience. A special mention of Akhil Ahuja ji will not be out of place for sharing his practical and personal experience in the domain. I'd like to express my gratitude to our IPNet President, Mr. Ashish Makhija, sir, for his wavering commitment and visionary leadership, which has made IPNet a platform of immense significance for insolvency professionals across the country. Sir, thank you for being guiding light to all of us, though you are not here, but please accept our gratitude. Special note of appreciation goes to our moderator, IP Namrata Nanderi ji. Her valuable insights and depth of understanding the topic has greatly enhanced today's discussions. Special thanks to invaluable contributions of transition and the technical support teams. The seamless coordination and tireless efforts behind the scenes ensured a smooth conduct of webinar. Our gratitude to all the participants who joined us today. Your enthusiasm, active engagement, and thought-provoking contributions have truly made this event special. And last but not the least, our sincere thanks to Mr. Sandeep Chatkara for wonderfully anchoring the webinar. Thank you all once again for joining in.